Mayor Lennon.
Okay, back to the Senate Judiciary, switching gears to 578, April 16th, and we have Ledge Council picking up where we left off either yesterday or perhaps the day before. They all kind of fell together, but we had some recommended edits, and I think we were about halfway through and we had to stop, and so we're just picking up from there. So, floor is always first.
Great. For the record, Hillary Shutter Ames for the Office of Legislative Counsel. Yesterday, time flies, we got partway through the edits from Lisa Mylott, so we can finish the other half of those edits. And then I believe there's a suggested amendment related to a surcharge that I can share. And then, of course, anything else the committee would like to discuss. So we left off on the second page of the edits from Lisa. So this is the top of the second page, page 19, the time frame for the forfeiture hearing. So just a reminder of where we are in the bill. This is the section talking about the forfeiture proceeding. And it talks about notice, it talks about timelines and other requirements related to the forfeiture proceeding. So at the top of page 19, we are looking at page 19, lines 8 through 15. This subdivision is talking about the timelines for the court hearing and the timelines for later, the timelines for the owner posting security. So hearing 3A, as passed by the House, the bill currently provides that an owner has 14 days after seizure of the animal to make a request for a forfeiture hearing. Earlier in the bill, it says if they don't make a request within 14 days, then they have essentially declined to challenge the forfeiture and the animal, title to the animal is forfeited. If the defendant requests that they want a forfeiture hearing, they can also request that the security be reduced or waived, and the court has to grant or deny the request before it holds the forfeiture hearing. There's also a timeline, and this is what's relevant to the suggested edit, that the court hold the hearing within 30 days after the owner requests the forfeiture hearing, unless the 30-day period is extended by the court for good cause shown. So it's a 30-day deadline for the court to hold the hearing that starts when the person requests the hearing, but as currently drafted, it allows the court to extend that time period for good cause. The suggested edit from Lisa would be on lines 13 through 14, and it would strike the phrase unless the 30-day period is extended by the court for good cause shown. So that would require the court hard deadline, hold the hearing within 30 days after the owner requests it, without permission to extend it. That's a policy question for the committee. I believe the plan is to hear from Judge Sone at some point. At this time, he will have things to share, but nothing further from me on that suggestion.
I was just going to say I had a little back and forth with the witness yesterday about that. And I would support that for sure, because it seems like otherwise you can have a situation where it's 74 days, before this piece of this gets resolved. And all we've heard about the money that gets spent during that time caring for the animals. So
the damage to the animals.
Yeah.
The damage to the animals being
During that time.
I mean, we've heard from multiple witnesses that animals degrade quickly.
Oh, yes, yeah. Okay, so you said 74.
So in other words, you have 14 days to request.
Yeah.
Then there's 30 days to hold it, or with good cause, 60 days.
Yes.
So it's a long time, two and a half months.
Well, yeah, I mean, that's one we still have to hear from Zone A of, I think. I know I'm not speaking for them, but from what I recall, there's a general concern about putting these short, strict timelines on hearings. At least that's what we were hearing on another bill earlier, but in this case, we were talking about a living animal that is being stored somewhere or housed somewhere, as opposed to property that may just be sitting around. So,
Actually, now that I read it, it's not
It's not necessarily 60 days.
right.
Yeah.
So a judge could say 5 more days or 10 more.
So in the previous bill, there was this 90-day for a final hearing. This is just hearings, right? So like a hearing could be held and there could be decisions made that, oh, we're gonna need this motion and another hearing.
This is the forfeiture.
Oh, okay.
hearing. Yes, so even as drafted, it is shortening the time frame from existing law. But the suggestion would be a way to kind of further shorten it or make sure there's kind of a hard deadline. The court could hold it in 30 days, depending on its docket, but this suggestion would require working.
But if at that hearing, the court decided they needed more information or they needed like that.
I think that might be a question for Judge Zone.
Okay, that's fair.
You will be able to speak better than I about what a court might end up doing.
Yeah.
And whether that means that the 30-day deadline, right, or I guess what that might mean for the 30-day deadline being a hard or extendable one. The answer to that question might provide more information about how long.
That's a very fair point.
at the moment, I'm more inclined to keep a good cause shown piece there. But I think we should probably get more testimony on it. I mean, good cause isn't, somebody just saying they feel like coming in a week because they're going on vacation. Well, actually, maybe vacation news, but
See, it's grand.
They were considering that.
if it was previously scheduled before,
Months.
yeah, then it could be. But I mean, you can't just delay just for fun. Okay, yeah. So I think we'll just put a pin in that for now.
All right.
Just come back to it.
Moving forward to the next edit then, this is in the next subdivision. So this is 3B on the bottom of page 19 that will run onto page 19. This section is about posting security. So subdivision B describes that the person needs to post initial security within 14 days of the seizure, unless they request a reduction or waiver for financial hardship. And that reduction or waiver for financial hardship option is something to protect due process rights, not including that would be a due process issue. So you'll see later, there are a couple edits where I'll suggest just clarifying that that is always the case. But the owner has to post security within 14 days of the seizure. They do that for an initial 40-day period. And then if needed, it would be an additional amount for 30-day periods.
I'm sorry,
Every
where
30
in the
days
bill
thereafter.
are you right?
This is page 19, subdivision 3B. So line 6, starting on line 60. Thank you. And then running out to that page. So that is what the current subdivision B describes. There was a question yesterday that the amount of the security and payment schedule are decided or shall be set by rules adopted by the Director of Animal Welfare. The suggested edit would be on page 20, line 2, at the end of the sentence about the rules. So right before at the end of line 2 on page 20. The suggestion is to add failure to pay. Oops, not there, sorry. It would be on page 19, line 21. This first sentence says, person who wants a forfeiture hearing has to post security for these periods. And the suggestion from Lisa would be to add after that sentence, failure to pay such amount when due shall result in forfeiture to title to the animal. So I think the challenge described throughout the security provisions is that if there is no stick in having to pay security, it makes it very hard for the organizations to keep holding the animals, pay for the animals. There's going to be a security requirement. That's why there are some provisions about or like a suggestion that failing to pay should result in forfeiture to title to an animal. One minimal suggestion that I would add is, at the end, so it would say failure to pay such amount when due shall result in forfeiture of title to the animal, comma, unless a financial waiver request is made or granted. That would be a kind of minimal due process protection. I think it's the committee's been hearing in relation to other bills, there are generally some procedural due process questions when you are dealing with this kind of scenario. And I have not found a case saying you can't do it or a case saying you can do it with regard to, as long as you allow for a waiver or reduction for financial hardship, forfeiting for failure to pay, not clear that it's definitely a procedural due process issue or not, but that is an argument that defendants have raised in challenges ordinances mostly, similar to this.
I'm wondering, it says a person shall post security. And then you're suggesting edit says when due, but there's no time frame specified unless I'm missing it.
There is. So I had a similar question in reading this. I think it's it's kind of a like best of two unideal alternatives. This section essentially says, you have to post security first for a 40-day period, then for 30-day periods. Failing to do that, unless you request a waiver, results in forfeiture. Later, it specifies when the first payment has to be made. I think I'm happy to adjust the order of this a little bit to make that clearer because I similarly had a question. But it is in there. I think one edit that can also clarify that is this is page 20, starting on line 2 at the end. Right now it reads, the security shall be posted within 14 days following the seizure, unless the person requests that the security be reduced or waived by the court on the basis of financial hardship. So first payment due in 14 days, unless you request a waiver. I would suggest adding initial right before security. So it would read the initial security shall be posted within 14 days. And that way you might have that same question when you read the first sentence, but it'll be a little bit clearer when you get to that sentence that the timeline starts 14 days for the initial security.
Why is it 14 days instead of within 30 days prior to the hearing? Or is that the question you can't answer?
So your question is why aren't you keying security based off of the hearing such that if the court is pushing the hearing out? I think maybe I'm going to answer the question. Right now the timeline is seizure. Person has 14 days to request a hearing. If they don't request a hearing, title to the animal is forfeited. We are out of this procedure. If they do request a hearing within 14 days, they also, as currently drafted, have to post security within that 14-day period to start paying for the cost of care. Within 30 days, the court has to hold a hearing. But it could be longer and it also could be shorter. So I think the challenge with keying it off the hearing is that you won't actually know, the owner might not know, they might have less than 30 days notice of the court's hearing, I guess, the only way to say it. So it's cleaner to count from the seizure than backwards from the hearing.
Just trying to fully understand the timelines here. Okay.
They are a lot to grapple with, so understandable.
It seems to make sense to me as well that you have the 14-day window to say, no, I want a hearing. And at that same time, you are now triggering, you need to post the security because you're not just working. So that trigger makes sense to me, both procedurally and just sort of logically.
And what they will be asked for or told that they have to post is enough to cover a 40-day period.
Correct.
Okay.
Which is essentially I think the idea is that will cover through the hearing unless extended. And at that point, but in 40 days is, if the court's going to hold it within 30 days, you should be able to cover the costs of care pretty close to the hearing, maybe a little before, maybe a little after. But I think that's the idea behind the 40 days.
Oh.
And I assume, and maybe it's in the language and I just don't see it, that if the hearing is held in 20 days and the person, it is determined that the person won't forfeit the animals, that any money that wasn't spent would be returned to them.
I believe so. I can't point it to you right off the bat.
I was trying to
Before the end of today. But yes, it is. I believe it is. And I think we'll get there with some of the other edits, so. So I guess, any other questions about those two suggested edits?
Senator, your recommendation was to add the word initial on line 2.
Yeah, I agree with that addition. It's not line
It would be page 20, line
3. Yep.
Yes, it'll fall in between the last word on line 2 and the first word on line 3.
Yeah.
So the question is, do we add the sentence, to pay such an amount when due shall result in forfeiture to title to the animal?
Unless a financial waiver request is made or granted, it's my suggested addition if the committee wants to add the failure to pay sentence. If the subdivision later mentions the financial hardship waiver, but just, that's like our one really clear due process commandment in this context. And so being very clear that you can't forfeit title to the animal without being able to choose to access the court hearing. And if you don't have enough money, that's not a reason that you lose access to the hearing.
Yeah. Thoughts? Senator,
Just a quick question, Hillary. When you refer to the title to the animal, what do you refer to? Just a court order saying, okay, people lost this, or what was, I know what a title to a car is, or what's the title to an animal?
Other witnesses might have cleaner answers. I think maybe some people have a clean legal document that says that they purchased this very fancy pet. Some of us also adopt pets and don't have a document showing title.
AKC registration, for instance.
But I think the idea is if the court is ordering forfeiture of title to the animal, it's just a way of saying you no longer have a legal ownership right to the animal. But I might suggest you ask other witnesses for cleaner answers.
I was just curious.
Yeah.
I would support adding that sentence. I just think it's a great clarification of what's in happening.
any other thoughts? So I guess we're undecided on that. So we'll push in it until we'll figure it out.
All right. The next edit would fall at the end of this section. So this is page 20 at the end of line 6. It would add to the last sentence such that it would read as follows. The court shall collect and transfer the security to the Animal Welfare Fund established pursuant to 20 VSA 3203. And the Director of Animal Welfare shall pay such amounts up to the security received to the custodial caretaker upon receipt of proof of expenditure of funds by such caretaker for food and or necessary veterinary expenses for such animal. And I think that's just to clarify something that is already in the bill, which is that the Director of Animal Welfare can make payments from the fund to custodial caretakers for costs of care.
Is that the fund that Senator Williams is trying to establish?
So there is a fund in current law. The Animal Welfare Fund exists. Because there are different ways to fund it, and there are currently some ways in existing law that provide for how it gets funded. It gets funded by a percentage of a surcharge on various criminal violations and civil penalties, and a few other things. This bill, as drafted, would add other ways to fund it, one of them being the security that we're talking about. Now the defendants are required to post the security would go into, collected by the court, goes into the Animal Welfare Fund. And then the Director of Animal Welfare can make payments for cost of care or other payments from that fund. Senator Williams' suggestion is an additional way, in addition to the security, of funding that existing fund, which would be, we can talk about it in more detail, after we finish these edits, but it would be imposing a surcharge on any person, convicted of violating these animal welfare provisions.
Senator Booth.
So, I'm thinking through in the sentence, the suggested sentence that you read, it adds necessary veterinary costs.
Correct, necessary veterinary expenses.
Right, and so what I'm wondering is, you have somebody who's issued a financial hardship waiver. Now it's going forward, it's not just room and board, it could add, because I assume that the custodial entity has to do whatever is necessary to keep the animal alive, right? They can't choose not to, if there's as we all know, I think, who've had animals, a veterinary procedure can suddenly balloon into thousands and thousands of dollars. So what I'm wondering is, if somebody submitted a waiver of financial hardship, so they're saying, I don't have any, and then you're boarding their animal or animals, sometimes multiple animals, and these costs are just jacking up. It seems pretty obvious to me that in the final order, where they're issued the bill, essentially, that they're gonna say, I can't pay that. Is there any way that the bill, I mean, do you see what I'm getting at? So you have somebody who's attesting to the court, I don't have any money. But then on the other hand, this bill is just jacking up. And then it's gonna leave the animal welfare fund to cover that expense, I believe. That seems like a loophole there that will bankrupt the fund in certain instances, like when you have those 50 dogs, 50 houses that were taken. If they had all needed some kind of intervention, you'd be talking about a lot of money. So any thought on that?
I'll defer to other witnesses about projections for the fund under that scenario. But I think that is flagging kind of the tension underlying or driving the changes to the statute, are that there might not be a perfect way to deal with that, but if you shorten the timeframes, that's reducing the amount of
Yes.
potential costs you can run up. So that's kind of my short answer, but I would defer really to Lisa about the animal welfare fund specifically.
Lisa, do you want to chime in on that question real quick?
Sure, Lisa Milet, Director of Animal Welfare. The way this is written is that the Animal Welfare Fund will only disperse amounts for any given animal up to the security amount paid. We anticipate that most defendants are going to ask for that waiver, given that it prolongs when they have to pay something. So I honestly don't think much will be coming into here from the security. So the nonprofits will still bear them. The Animal Welfare Fund right now, its only funding mechanism is a $2 per dog license fee surcharge, and that is about $30,000 a year less than needed to pay my salary, because the fund pays my salary. And so there are no excess funds in there to cover any expenses. I think that's part of but that's actually largely what Senator Williams is trying to get to with his proposed amendment, is having a surcharge. I think it's a $50 surcharge per offense, and I think it would have to be per charge for it to actually have any effect. So if there's 55 charges, it would be $50 per dog. Because if it's $50 per defendant, we're talking $500 a year is going to come in there, and that doesn't help with anything. But that's part of what Senator Williams is trying to deal with, is the fact that there's always going to be a shortfall. The initial security amount is only the anticipated cost of food and cost of needed vet care as the law enforcement officer moving an animal. So those amounts are going to be relatively low. It doesn't cover board, so it doesn't cover the care costs.
Yeah.
So the security is, first of all, always going to be less than the cost. And we anticipate that it's going to be far less than the cost because of the waivers, which will undoubtedly be granted. So it's not, the amounts payable under that provision will not bankrupt the fund, because they are capped at the amount that came in for that animal.
Understood. Who would eat those costs? Would it be the veterinarians? So let's say, you have an animal welfare center that's agreed to board 10 animals. and it's discovered that they have like, I don't know, chronic hip dysplasia and, they're in pain. They can't put the animal down, from what I understand, because they don't have title to it.
It depends. If it's a bad enough condition, they can, if a vet is saying this animal is suffering, it can't reasonably be moved, I don't know the exact terms, the animal could get euthanized. As it is, sometimes veterinarians just don't get defaulted on. You're right, veterinarians sometimes eat the costs, sometimes private organizations. Dorset Equine, I believe in their committee says they've spent hundreds of thousands of dollars that are unreimbursed from any source. Or the shelter or private organization is bearing them. And so that is to Hillary's point before, that's a lot of what this is trying to do, is if we have timeframes that are, currently there is a 21-day period for a hearing or civil forfeiture from the time of the scheduling conference. But since it's not binding, that becomes 4 months, 5 months, 6 months. And so the fact that these things get drawn out just drive up those costs astronomically, because the rescues and shelters can't really publicize the animals for donations either during that time, because they are evidence in the criminal case and we don't want to prejudice the defendant. They need a fair trial. And so getting title forfeited quickly is the best of a bunch of bad solutions, unless there's a pot of money I don't know about that could fund it.
And that's helpful. And this is probably for a later day, because the key solution here is speeding up the timeframes. But I would just say, if somebody has declared financial hardship and then this bill is running up to a certain thing, there's an inherent hypocrisy there, it seems. If the person is truly unable to cover the boarding costs, they're not going to be able to cover those costs, and plus necessary vet costs. So it seems like we're saying, okay, you have financial hardship, but we're going to act as though you still have title and you're going to pay all of these costs at the end. So maybe that's just impossible to get rid of with due process, but
I think what you just explained is also part of the rationale for treating this differently for due process purposes, right? Like that's part of the explanation for why you can forfeit order forfeiture earlier than you might otherwise be able to. To your question, there is a provision in existing law that gets at some of the costs and what a humane officer can do. So this is page 15 at the bottom. It starts back in C. A humane officer shall provide suitable care at a reasonable cost for an animal seized under this section. They may arrange for the euthanasia of a severely injured, diseased, or suffering animal upon the recommendation of a licensed veterinarian. And there are some other provisions. I'm less familiar with them, so if you have further questions, I may need to report back. But there are some provisions in current law that speak to reasonable cost or severely injured.
I'm looking at this next sentence. Humane officer may arrange for euthanasia under the section when an owner is unwilling or unable to provide necessary medical attention while the animal is in custodial care. So it seems like when they're in custodial care, the current procedure would be to reach out to the owner and ask them to cover the necessary vet expenses. That's what seems to
In
be.
practice, that does not happen. I don't know of any circumstance where an owner has actually paid in for something like that. And so part of the tension is the Humane Society or other custodial caretaker would rather treat than kill, right? But that tells them that if the owner won't pay, you can have the animal euthanized, and that is not a good outcome. And so so these things are all interrelated.
Yeah.
But I don't know of a single case where an owner has paid in for medical expenses while the animal's being killed.
Do you know of a case where they've been reached out to ask them?
No, I don't.
Okay. Fair enough. Thank you.
I do know that they've been asked to surrender so that the shelter can then make their decisions to care. And in the cases I know, the owners have said no.
So I guess any further questions on this, adding these 3 lines
Where it starts
on the
with,
page and the director of animal welfare.
where it starts with the lines, the court shall collect and transfer.
Yes.
Then ends with for such animal.
Correct.
And you would describe this as kind of a technical change.
Yeah, I think it makes it consistent with what you'll see later in the animal welfare fund provision, which says the director of animal welfare can make these kinds of payments from.
What do folks think?
You know, that we're sort of setting it up to do, it seems reasonable to allow them to do it.
I would agree. Anybody opposed to adding this?
Great, I will, we will make some tweaks because we generally don't use and or in, statutory drafting, but, I will include that.
Just a quick question, Hillary, maybe for Lisa, on page 26, line 12. On the animal welfare fund. It does make a statement, appropriations made by the General Assembly. Is there presently an appropriation? This is an anticipation of
The possibility,
possibility. Okay, thank you.
the unlikely possibility for the moment, but you never know what the future brings.
All right, thank you.
All right, moving forward. The next edit is back on page 20. Subsection C, this starts on line 7, is talking about the hearing, what the state has to prove, what the court has to find, and when the court has to issue a final order. So as currently drafted, the court shall make findings of fact and conclusions of law and shall issue a final order promptly. The suggested edit from Lisa is to change promptly to within 7 days. So it's providing a firm deadline as opposed to a looser one of 7 days for the court to issue an order. That's a policy decision for the committee. I think similar to the other court deadline related edits that Judge Zoning or other instances might be able to provide for those.
I suspect 7 days won't be feasible. Well, I don't want to assume what Judge Zoning will say, actually. That's very prompt. So that's something we're gonna have to hear about testimony on.
The next edit is in the following sentence, which is just a kind of technical correction. The findings shall include the total amount of costs incurred by the custodial caretaker instead of caregiver. Statute generally uses caretaker and not caregiver, so this is just a way to make sure we're using the same term throughout. Any questions about that one before we move forward?
Well, I guess, I mean, if the findings are meant to determine whether or not animal cruelty, neglect, or abandonment has happened, I'm not sure why the findings would also need to include the costs.
In an upcoming provision, you will see that if the court does not enter an order of forfeiture, but the court finds there was probable cause for the underlying seizure, to get the animal back, the owner has to pay the remaining cost of care. They have to pay it before they can receive the animal back.
Would they, I know this further along, would they have the waiver if there's financial hardship in that scenario too?
I not as currently drafted.
Suspect. Yeah, I mean, that's something that I would want to consider further. Maybe any thoughts on either the lines 11 through 12 or what I just mentioned regarding the waiver, or if the forfeiture, if the defendant prevails in the forfeiture hearing and they're required to pay, but there's no waiver, and how would they get their animal back?
It would be somewhat problematic, I would think, because in fact we're not able to pay for this, and then the society or whatever would still withhold the animal and continue to incur cost. I'm not sure how we would
If I may, because the court is determining the costs, what we've seen is the courts will determine what they will take into account ability to pay, and that could be explicitly written in this. But that's the reason we're having the court determine the cost. So it's not just they get a bill, it's the court says, yes, you should pay this amount. And so for due purposes, it should be clear the court can determine the cost as appropriate given financial situation. If that makes sense.
Yeah, that makes more sense.
I would recommend
Right.
adding some language there, and I think
Yeah.
potentially later
Yeah.
to specify that.
I think we'll spend just another 5 more minutes on this one. Switch gears to railroads.
Right.
Right.
I think in that time, we,
Actually, we'll give it 10 minutes.
then I think we'll be able to make it through the rest of Lisa's edits. So the next edit will be on page 22. So this is subsection E, and this is what we were just talking about, that if the court orders and enter a forfeiture, the animal's forfeited. But if the court does not enter an order of forfeiture, subsection C describes what happens. The person, the owner, person claiming the interest in the animal has to pay the custodial caretaker actual cost of care and keeping during the period of impound, including veterinary care, and the amount in excess of any security paid. They're not double paying if they're already paid in security, since the costs subtracted with the security subtracted. But the person does not, they have to make that payment before they can get the animal, but they don't have to pay the cost of care if the court finds that there was no reasonable basis for the seizure in the first place. So the court can basically think two things about the warrant for the seizure. That there was no reasonable basis for the seizure, or that there was probable cause for the seizure was proper, but the state still hasn't proven by preponderance that the animal prohibitions were violated. In that first scenario, if the court thinks that there was no reasonable basis for the seizure, the person does not pay the cost, they just get their animal back. But if the court finds that there was probable cause for the seizure, but obviously did not enter an order of forfeiture as drafted, the person has to pay the remaining cost of care before they get the animal back. So it sounds like there is further thinking about how that should be drafted. The suggestion here, there are a few. The first, I guess, is to specify what I just described, that the cost of care should be in excess of security paid. So clarifying that there's no double payment. If a person has paid security in, they won't have to, their amount for that. The next suggestion starts on line 8. So right now it reads, if payment of the cost required by this subsection is not made within 14 days after the order, the custodial caretaker's costs not to exceed the amount of security posted pursuant to subdivision D3B of this section shall be reimbursed from the Animal Welfare Fund established pursuant to 20 VSA 3203. The first suggested edit is to change the deadline from you have to pay by within 14 days of the final order, or the custodial caretaker gets reimbursed to 7. So that's Paul's question. With the caveat that it will, there are several edits to this section and they all kind of work together. So there's a suggestion to change the 14 days to 7. Where it says not to exceed the amount of security posted. The suggestion is to add not to exceed the amount of remaining security posted. Again, I think to clarify, if someone has paid in security, we're going to be thinking about that when we're considering what else is left to pay. And the third suggestion is to add at the end of the sentence that I've been reading, this would be at the end of line 12, and title to the animal will be forfeited. So the scenario here is the animal is held by the custodial caretaker, but the court decides no forfeiture. if there was at least probable cause for the seizure, the owner, to get the animal back, has to pay for remaining costs of care. The suggestion is, and if they don't within currently 14 days, then the custodial caretaker gets reimbursed from the animal welfare fund. The suggestion is, and they would lose title to the animal, they would forfeit title to the animal. So non-payment would result in non-payment within 14 or 7 days would result in forfeiting the animal. And the suggestion again earlier that all of this is taking into account financial hardship is something that should be reflected here too. So there are a couple ways we can do that, but that's just the one suggestion that if the committee is interested in having the title to the animal be forfeited, that it have some provision for.
And thought.
Yeah, if we add the financial hardship piece, because if that kind of deadline out and add in the hardship part, we get, makes sense to. If somebody is able to pay, they can do it in 7 days as opposed to 14.
And if they don't, the animal's forfeited.
So there have been kind of due process related challenges to some provisions like this, but those provisions didn't explicitly include financial hardship. And the issue there in those kinds of challenges is more of a procedural due process issue. So as long as the person is getting a chance before a judge to explain why they shouldn't have to pay the amount, there's a pretty good argument that it's fine. But this is a not entirely clear area of law. There have been arguments like that, but it's not clear what a court would say about that provision. It just speaks to, I think, something you said earlier, Sandra, that the court's looking at some provisions like this. Their intuition is, well, the person wasn't found by or state to not prove that the person violated the animal cruelty provisions, but they're still being forced to make this payment to get the animal back. And some courts have at least considered that kind of scenario raises some fairness concerns, but they haven't specifically addressed that kind of argument in the context of a provision that
Fine with reducing it to 7 days, but I'm not there yet on having the animal forfeited in that circumstance. Sorry, just a quick focus.
It's hard for me to wrap my head around and talk about
Let me go ask people.
not being able,
I've already been out there twice.
not being able to,
Somebody's time.
pay for the rest. We don't have any idea what we're talking about.
Yeah.
You know, what makes you interested? Is it $100? Is it $1,000? I'm trying to wrap myself around someone can't
question
afford
for
to pay
another
for this.
witness.
Is it $1? I mean, what, just give me a ballpark or something we're talking about.
For indigency, I mean, it would just be what the court believes. The difficulty here is that right now, it doesn't say what happens to the animal if the person does not pay the amount they're supposed to pay. It just leaves it open. Does that animal continue to be held? Because the custodial caretaker has a lien against it. So in theory, that animal now is just held until the criminal trial, which could be years. And so there needs to be a gap filling of some sort. And 40 states have provisions that have the forfeiture of title if you don't pay the amount it's due. So that's the predominant. Most states only deal with the money part of this whole question. And they all say, if you're supposed to pay the amount and you don't, title's forfeited. Because if you say that the animal goes back without forfeiture of title, everyone will just wait for 14 days. Or nobody will ever pay the cost due, right? A rational person will get land back free instead of paying today and getting land back. And so there has to be a gap filling, and that's your policy choice, but it has to be filled in some way. And I would say if you're going to give the animal back without them paying, it should just be immediate. It should be like the no probable cause for impounding. Don't make them hold it for another 14 days and make the animal suffer for 14 more days, make the nonprofit incur costs for 14 more days, because the rational person will never pay if they get their animal back without paying.
But it's still, the question still remains, through your experience, What do you see for charges?
It depends on, it's so much.
Just give me a
depends.
ballpark. Just throw something out there.
Okay, for a horse, it might be $20,000.
Okay.
For a dog, it might be $100. It just, the problem is it's all over the place. It depends on the type of animal, whether it was trauma or starvation.
How long they've
Starvation,
had it and so on before.
starvation, it's just purely feeding the animals where the cost is going to come in, and that's relatively low. Trauma, somebody who beats their animal, that could be $10,000, not that hard. So the problem is it's a huge range depending on what exactly happened to this animal. And I think having a court be able to decide, is this an amount I'm going to make this person pay? I think that makes a lot of sense in every way. I think I definitely want to protect the person as well as the animal. And if it's appropriate for you, it should.
So
But there's money.
how about 14 days? Potential waiver and the animal gets forfeited if they don't pay. Does that cover the gap that everyone has? Is there anybody opposed to that as a? Can we do that, please? Thank you.
All right, we are on the final section of suggested edits. And this has to do with the appeal. So if a person, if the court orders a forfeiture, finds that the state has proven by a preponderance that violations of the animal cruelty provisions have occurred, then the owner can appeal. The suggested edits touch on deadlines and on cost of care during the appeal. So this is page 24. Starting on line 1, section subdivision G1. This suggested edit would add deadlines for appeal. So as currently drafted, it just read a forfeiture order, it would shorten deadlines. A forfeiture order issued under this section may be appealed as a matter of right to the Supreme Court if a notice of appeal is filed within 7 days after the order is issued and the appellant posts security as the next section describes. So currently as drafted, there's just a deadline to file a notice of appeal within 7 days, but there's no deadline for the Supreme Court issuing an order. The suggested edits from Lisa would add such appeal shall be heard within 14 days of such filing, with a final decision issued within 7 days of such a hearing. So right now, as drafted, there's just owner has to file a notice of appeal within 7 days. Whatever appeal process happens after that is up to the Supreme Court. The suggested edit is that it would keep you have to file your notice of appeal within 7 days. You can tell the court that you're going to appeal it. The appeal has to be heard within 14 days. So that's briefing and a hearing scheduled within 14 days. And the Supreme Court has to issue a final decision within 7 days of such hearing. I'm not aware of other requirements like this. Again, I think we will hear testimony from Judge Zone, and I expect you would have something to share on this provision.
Yeah, my initial reaction is some sort of hesitation. Maybe I'm not fully understanding it yet, but it almost seems like we would be placing a requirement on somebody's ability to appeal something, the Vermont Supreme Court.
So having a deadline to file a notice of appeal, that's not like there are existing deadlines to file notice of appeal. This is just a shorter one. But the idea that the requirement that the Supreme Court hear the case within a certain timeline, within 14 days, and issue a final decision within 7 days of that hearing, that's the suggested change that is being proposed.
I think maybe I was getting too far ahead and looking at the security.
Yes, that's good.
Yeah.
So any other questions on at least the proposed change for the appeal hearing and decision deadlines?
Does that include post security pursuant to subdivision 2? Does that include financial hardship? Like if you couldn't pay it before and you can't pay it,
That's something I will suggest adding.
Oh,
Yes. So the G1 is just appeal deadlines, and G2, which we'll turn to next, is the security.
Oh, okay.
What to do with security. The suggestion there is this is similar to what you saw before at the, initial court level. This is page 24, line 11. It starts by saying in subdivision 2 on line 6, the appellant shall post security necessary to cover food and necessary veterinary care for the animal for an initial 40-day period. So basically to appeal, you have to put in some money to cover costs during the appeal. Lisa's suggestion is to add after that sentence, this would be on line 11, after the period after case. Failure to pay such amount when due shall result in forfeiture to title to the animal. And to both of your questions, I think I would recommend adding unless financial waiver is requested, and unless a financial waiver request is made or granted. So again, you're adding the financial waiver reduction, the financial hardship waiver or reduction to the security requirement. The other two suggestions, or the few suggestions, are the first is a technical change, and the second is consistent with a change the committee thought made sense earlier. So this is page 24, line 11. It currently reads, the amount of the security and the payment schedule shall be set in rules adopted by the Director of Animal Welfare pursuant to 20 BSA 3202E. Suggestion from Lisa is to change the calculation of the security and to remove the phrase and the payment schedule. The payment schedule is set out in the first sentence, pay it within the initial 40 days and then 30-day period. And I think calculation instead of amount is just a different way of saying the same thing. I think Lisa's suggestion is that calculation made more sense to her for what the rules will be specifying. The final edit is that this final sentence, the court shall collect and transfer the security to the Animal Welfare Fund established pursuant to 20 GSA 3203. Lisa is suggesting adding, and the Director of Animal Welfare shall pay such amounts up to the security received to the custodial caretaker upon receipt of proof of expenditure of funds by such person for the care and or keeping of such animal. And again, I think that's implementing what we have in the Animal Welfare Fund section, that the Director of Animal Welfare can make payments from that fund for custodial caretaker costs. Any other questions? That rounds out the suggestions from Lisa. Any other questions or anything else I can help with?
I think I'll need to mull over this last change regarding appeals before forming any opinion on it. So I get that. I don't have much. Committee, anything else?
Not on Lisa's changes.
Okay. Anything else? Okay.
So I think our 10 minutes is up,
Yeah.
but when the committee would like to hear about the surcharge proposal, I'm sure.
Fantastic. Yeah, we'll get back to this next week, and yeah, thank you.
Great. And would you like a draft for discussion next week?
Yeah, I think that would be
Great.
helpful. Thank you.
Yeah, that was the edits agreed upon so far, and then if there are more.
Perfect. 181. So we'll do 181, and then when Phil gets here, we'll go back to 261.
Chair evaluation. I thought we were done with that.
You are. You're gonna be done with that in like 60 seconds.
Okay.
We're done with both.
Lovely. I like that.
All right, good morning. So for the record, Michelle Child, Office of Legislative Counsel, and we're taking a look at S 181. So this was your deferred sentencing bill where you removed the mandatory PSIs, right? So it was for, remember, you have subsection A, which is when the parties agree. So you have the defense and the prosecution agreeing to a deferred sentence. there was a requirement for a PSA in those circumstances, and those could be non-listed or listed crimes when there's an agreement. Then you have your subsection B, which is when the court does it when there's not an agreement between the parties, and the court is prohibited from ordering a deferred for listed crimes. You took out the PSIs for everything except the listed crimes. So listed crimes can only be, you can only agree to a deferred for a listed crime if you have the parties in agreement, and you put in there that you do need the PSI, but for no non-listed crimes. The amendment that you'll see in the calendar, and I had sent just a one sheeter to Emily, so I don't know if you had it on. You guys, all it does is in subsection A, it states what is the default already and what Judge Zone testified to, which is that that in the case of non-listed, no, I'm sorry, in the case of non-listed, the court at its discretion can order a PSI. So that kind of takes it off the mandatory so that it's not always having to be done for all non-listed crimes when there's an agreement by the party. But if the court, when the case is like, I feel like I need more information, I need more background, but Judge Zone testified that they have the ability to do that now. So you decided, okay, that's fine, that's sufficient. House Judiciary just wanted to put it in the statute. So it's no substantive change as to the policy. It's just that it's there.
That a judge has the discretion to order a PSI for a non-listed offense if you want to, even though it's already in chapter 28, I think.
I think so.
28.
Yeah.
Yeah.
So I think they just wanted it in there because it says, because of the change.
Yeah.
So they just thought that.
Whatever makes them comfortable, right? How do people feel about this inconsequential change?
Well, I have strong opinions about a lot of things, but I generally try not to have them about inconsequential things.
If the house wants it, let's do it.
Yeah, okay, well, that sounds good. Thank you.
Sure.
And just want to make sure we heard your walkthrough of that one change. It's on the floor today, so
Yep.
I'll take care of that.
Okay.
Okay. Let's switch gears and go back to old issue that we talked about. It'd be good to have Bill here. I sent him a text, so I'll go. Actually, can we go off live for 5, maybe 10 minutes? So we'll have to go find Bill.
Well, reschedule.